So service dog handlers hear it all the time. How can I make my dog a service dog? I need to make my dog a service dog. Where do I certify my service dog? How did you certify your service dog? So in this section, we've already discussed the definition of disability under the ADA, and that is the gateway to the ADA. If you don't meet that definition, the ADA can't help you. You do not fall under the ADA. It does not want you. So assuming that you fall under that definition, this section, we're going to get to the definition and the requirements of service dogs. It's going to be rather long. I'm going through 3 separate documents. I hope it's not too boring. I have stories and little things interspersed in there. But this section is going to be about the laws, under the ADA surrounding service dogs, what their definitions are, what they are and are not allowed to do, all of that. So let's go ahead and get started. Many people with disabilities use a service animal in order to fully participate in everyday life. Dogs can be trained to perform many important tasks to assist people with disabilities, such as providing stability for a person who has difficulty walking, picking up items for a person who uses a wheelchair, preventing a child with autism from wandering away, or alerting a person who has hearing loss when someone is approaching from behind. The Department of Justice continues to receive many questions about how the Americans with Disabilities Act applies to service animals. The ADA requires state and local government agencies, businesses, and nonprofit organizations, in parentheses, covered entities is what they're called, that provide goods or services to the public to make reasonable modifications in their policies, practices, or procedures when necessary to accommodate people with disabilities. The service animal rules fall under this general principle. Accordingly, entities that have a no pets policy generally must modify the policy to allow service animals into their facilities. This publication provides guidance on the ADA's service animal provisions and should be read in conjunction with the publication ADA Revised Requirements Service Animals, and we'll get to that. Definition of a service animal. Now, as we go through this, keep in mind, these terms they use are legal terms, and they are defined in the ADA, what they mean. So you cannot assign a different meaning to these terms. You have to go by the meaning that's detailed in the ADA. And I'll try to point them out as we go through them. What is a service animal? Under the ADA, a service animal is defined as a dog that has been individually trained to do work or perform tasks, plural, tasks, for an individual with a disability. The task, and then S in parentheses, performed by the dog must be directly related to the person's disability. Okay, the term disability has been defined in the ADA. So when they talk about the dog's been trained to do work or perform tasks to assist with a disability, they mean a disability as they have defined it in the ADA. What does do work or perform tasks mean? The dog must be trained to take a specific action when needed, either on its own or by cue, to assist the person with a disability. For example, a person with diabetes may have a dog that is trained to alert him when his blood sugar reaches high or low levels. A person with depression may have a dog that is trained to remind her to take her medication. Or a person who has epilepsy may have a dog that is trained to detect the onset of a seizure and then help the person remain safe during the seizure. So tasks are specific actions the dog takes. The way other advocates have put it to me is recognition and response. They recognize a condition, a cue. They recognize something that triggers them into the behavior, and then they do the behavior. Now, the trigger may be something out of the person's control that they've trained the dog to respond to. So when their body does this thing, it triggers the dog to do the action. But there has to be recognition of some kind of trigger or cue and the response of the dog doing it. Are emotional support, therapy, comfort, or companion animals considered service animals under the ADA? No. These terms are used to describe animals that provide comfort just by being with a person. Because they have not been trained to perform a specific job or task, they do not qualify as service animals under the ADA. However, some state or local governments have laws that allow people to take emotional support animals into public places. Not many. San Francisco is one of those places. And there is one or two others I've heard of across the nation, but most places this is not the case. You may check with your state and local government agencies to find out about these laws. If someone's dog calms them when having an anxiety attack, does this qualify it as a service animal? It depends. The ADA makes a distinction between psychiatric service animals and emotional support animals. If the dog has been trained to sense that an anxiety attack is about to happen, and it says, if the dog has been trained to do this, not if it does it on its own. If the dog has been trained to sense that an anxiety attack is about to happen and takes a specific action to help avoid the attack or lessen its impact, that would qualify as a service animal. However, if the dog's mere presence provides comfort, that would not be considered a service animal under the ADA. Does the ADA require service animals to be professionally trained? No. People with disabilities have the right to train the dog themselves and are not required to use a professional service dog training program. This is not an excuse for a person to not train their dog and then lie about it. The training actually has to happen, and it has to be done well. If you don't know how to train a dog, then you go get help to find out how to train the dog and have somebody mentor you through the process. This is not a convenient loophole to say your dog is trained when it's not. You must do the training. Are service animals in training considered service animals under the ADA? No. Under the ADA, the dog must already be trained before it can be taken into public places. However, some state or local laws cover animals that are still in training. My state's one of those places. So I may take a dog in training out in public. Other places do not allow it. General rules. What questions can a covered entity, and we went over what covered entities are, businesses, state and local governments, what questions can a covered entity's employees ask to determine if a dog is a service animal? In situations where it is not obvious that the dog is a service animal, now let's read that again. In situations where it is not obvious that the dog is a service animal, staff may ask only two specific questions, and they can word it slightly differently, but the flavor has to be the same. 1, is the dog a service animal required because of a disability? They might also ask, oh, are you disabled? And that would be appropriate too. Some non-invasive question just to determine if you have a disability, basically. And 2, what work or task has the dog been trained to perform? And again, that might be worded somewhat differently, but with the same intent to ask, what is the dog trained to do? What does it do for you? Staff are not allowed to request any documentation for the dog, require that the dog demonstrate its task, or inquire about the specific nature of a person's disability. You can volunteer any of those things to them. If you feel like you want to, you may do so, but they can't require it of you. Do service animals have to wear a vest or patch or special harness identifying them as service animals? No. The ADA does not require service animals to wear a vest, ID tag, or specific harness. Basically, there is no rule about what way the dog has to be outfitted or dressed. You can do pretty much what you need and want to do. Oh, you can also not dress them at all, other than their leash and their collar, if you so choose. You do not have to wear any specific thing. Who is responsible for the care and supervision of a service animal? The handler is responsible for caring for and supervising the service animal, which includes toileting, feeding, grooming, and veterinary care. Covered entities are not obligated to supervise or otherwise care for a service animal. Again, they can volunteer, but they are not required to do so. Like you're at the hospital. You can't ask a nurse or the janitor or whatever employees nearby to take your dog outside. You can't do it because they are not obligated to do it. They can volunteer, but they're not obligated to. Can a person bring a service animal with them as they go through a salad bar or other self-service food lines? Yes, service animals must be allowed to accompany their handlers to and through self-service food lines. Similarly, service animals may not be prohibited from communal food preparation areas, a shared kitchen, such as are commonly found in shelters or dormitories. Can hotels assign designated rooms for guests with service animals out of consideration for other guests? No. A guest with a disability who uses a service animal must be provided the same opportunity to reserve any available room at the hotel as other guests without disabilities. They may not be restricted to pet-friendly rooms. Can hotels charge a cleaning fee for guests who have service animals? No. Hotels are not permitted to charge guests for cleaning the hair or dander shed by a service animal. However, if a guest's service animal causes damages to a guest room, a hotel is permitted to charge the same fee for damages as it would charge other guests. Can people bring more than one service animal into a public place? Generally, yes. Some people with disabilities may use more than one service animal to perform different tasks. For example, a person who has a visual disability and a seizure disorder may use one service animal to assist with wayfinding and another that is trained as a seizure alert dog. Other people may need two service animals for the same task, such as a person who needs two dogs to assist him or her with stability when walking. Staff may ask the two permissible questions about each of the dogs. If both dogs can be accommodated, both should be allowed in. In some circumstances, however, it may not be possible to accommodate more than one service animal. For example, in a crowded small restaurant. Only one dog may be able to fit under the table. The only other place for the second dog would be in the aisle, which would block the space between tables. In this case, staff may request that one of the dogs be left outside. Oh no, I'm not leaving my dog outside. If you put all that time and effort and money into training your service dog, do not ever, 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 ever leave it outside locked in a car, because cars can be dangerous if it's too hot. So if it's too hot, you can't leave it in your car, and you most certainly should not leave it tied outside. Dogs get stolen every day. Don't do it. You take your dogs and you leave. You go somewhere else, because nothing is worth, no meal is worth, the time and effort and money it takes to train a service dog. It just isn't. Does a hospital have to allow an inpatient with a disability to keep a service animal in his or her room? Generally, yes. Service animals must be allowed in patient rooms, and anywhere else in the hospital the public and patients are allowed to go. They cannot be excluded on the grounds that staff can provide the same services. However, this is true. However, in another section, we saw that the staff isn't responsible for taking care of your dog. So if you want to bring your dog into the hospital, you're going to have to figure out some way for the dog's needs to be met. Either you're going to be up to doing it, or you're going to have friends or family come in and do it, or you may choose to leave the dog home for the most part and have friends and family bring your dog to visit you, which could work too. But keep in mind, they're not required to take care of it. And if you're in a situation in the hospital where you can't do it, then you should probably leave the service dog at home. I've had medical tests where I was knocked out. My service dog had to stay at home because I was going to be unconscious. I couldn't possibly care for him, supervise him, handle him. So he had to stay at home. And here we go with the answer to that. What happens if a patient who uses a service animal is admitted to the hospital and is unable to care for or supervise their animal? If the patient is not able to care for the service animal, the patient can make arrangements for a family member or friend to come to the hospital to provide these services, as it is always preferable that the service animal and its handler not be separated, or to keep the dog during the hospitalization. If the patient is unable to care for the dog and is unable to arrange for someone else to care for the dog, the hospital may place the dog in a boarding facility until the patient is released, or make other appropriate arrangements. However, the hospital must give the patient the opportunity to make arrangements for the dog's care before taking such steps. I have tags, and I keep a flash drive with information on my dog. Say we were in a car accident and I was unconscious and his gear is on. They know he's a service dog, so they take him with us to the hospital, but here I am unconscious and they have this dog. I've got all the info on my dog about who they should call in that situation. If they can't, somebody, even animal control, even if animal control can temporarily keep him for the matter of an hour or two, then somebody, on my list, which is provided on the dog, can come pick him up and make sure he's seen to. That's how I handle that. Must a service animal be allowed to ride in an ambulance with its handler? Generally, yes. However, if the space in the ambulance is crowded and the dog's presence would interfere with the emergency medical staff's ability to treat the patient, staff should make other arrangements to have the dog transported to the hospital. Excuse me. Certification and registration. Does the ADA require that service animals be certified as service animals? No. Covered entities may not require documentation, such as proof that the animal has been certified, trained, or licensed as a service animal as a condition for entry. This means that when a service dog handler is going about their business out in public, these things cannot be demanded. That doesn't mean they shouldn't have documentation. It just means that it cannot be demanded of them when they're out and about doing their thing. I recommend everybody have their dog documented properly so that if you end up in some kind of legal battle, and you can be drawn into a legal battle without even wanting or meaning to be there. It can happen. I would have my dog all documented up so that when you find you're in the middle of something, you're not going to freak out because you already have it all lined up. Better to have it and not need it than not have it and need it desperately. That's my motto. In the little gray box, I want to draw everyone's attention to the little gray box. There are individuals and organizations that sell service animal certification or ASA certification or registration documents online. These documents do not convey any rights under the ADA, and the Department of Justice does not recognize them as proof that the dog is a service animal or an ASA in the case of fair housing. Let's read that again, everybody. There are individuals and organizations that sell service animal certification or registration documents online. These documents do not convey any rights under the ADA, and the Department of Justice, the Federal Department of Justice, does not recognize them as proof that the dog is a service animal or a donkey or a rock in the front yard. It proves nothing. Don't even bother. If you show those documents to out in public, somebody sees those documents, not everybody, but the word's getting around, you will be labeled a faker. You will be labeled to be breaking the law. Do you want to be labeled to be breaking the law? Especially if you're not. Don't go there. Don't show them. Don't get them. Don't touch them with a 100-foot pole. You do not need these documents if you are legitimate. You don't need them. Don't do it. Don't do it. My city requires all dogs to be vaccinated. Does this apply to my service animal? Yes. Individuals who have service animals are not exempt from local animal control or public health requirements. My city requires all dogs to be registered and licensed. Does this apply to my service animal? Yes. Service animals are subject to local dog licensing and registration requirements. However, under Title II, they are not allowed to charge you for it. They are not allowed to charge you an extra fee for access. And when we're talking about animal control, the fee they charge for a license to keep your dog in the county is essentially a fee for access to the county with your service dog. So they can't do it. They can't do it. So somebody, if they're doing that where you live, you might want to fight it. I'm more than willing to help you if you want to. My city requires me to register my dog as a service animal. Is this legal under the ADA? No. Mandatory registration of service animals is not permissible under the ADA. However, as stated above, service animals are subject to the same licensing and vaccination rules that are applied to all dogs. This is a problem. This is a conflict. And I'm going to let you guys know this. This is a conflict between Title II and Title III. When they're talking about city licensing, we're talking Title II, state and local government. Under Title II, state and local governments may not impose rules on us that are not that don't apply to pet owning people. Or am I saying this correctly? Okay. Title II says that they can't put requirements on you that non-dog owning people, have to live by. because the dog's a necessary medical item, medical equipment, they're not to put regular dog rules on you, basically, under Title II. I forget how they word it exactly, but the gist of it is they cannot put regular dog rules on you. They have to treat you as if that was a stuffed animal and not a real dog, basically under Title II. But here they're saying that we have to follow licensing laws. So there's a conflict there, and I don't know how they're going to resolve it or where they're going to resolve it. But my take on it, because the two titles are in or this guidance and Title II are in conflict, I will license my dog, because everybody, you know, is supposed to license their dog where I live. I will license my dog and tip my hat to the rule that says the dog has to be licensed, but I won't pay for it. That's how I handle it. Of course, my state handles it the same way. My state mandates you're not charged for, you know, licenses for service dogs, but not all states are like that. So I hope I made that clear. My city college offers a voluntary registration or registry program for people with disabilities who use service animals and provides a special tag identifying the dog as service animals. Is this legal under the ADA? Yes. Colleges and other entities such as local governments may offer voluntary registries. Many communities maintain a voluntary registry that serves a public purpose. For example, to ensure that emergency staff know to look for service animals during an emergency evacuation process. Some offer a benefit, such as a reduced dog license fee for individuals who register their service animals. Registries for purposes like this are permitted under the ADA because they are voluntary. You can choose not to do them. An entity may not, however, require that a dog be registered as a service animal as a condition of being permitted in public places. This would be a violation of the ADA. Breeds. Can service animals be any breed of dog? Yes. The ADA does not restrict the type of dog breeds that can be service animals. If you look down in the corner, my little icon is a headshot of one of my service dogs. Can individuals with disabilities be refused access to a facility based solely on the breed of their service animal? No. A service animal may not be excluded based on assumptions or stereotypes about the animal's breed or how the animal might behave. Pit bulls. However, if a particular service animal actually behaves in a way that poses a direct threat to the health or safety of others, has a history of such behavior, I don't know how they'd know that, or is not under the control of the handler, that animal may be excluded. If an animal is excluded for such reasons, staff must still offer their goods or services to the person without the animal present. If a municipality has an ordinance that bans certain dog breeds, does the ban apply to service animals? No. Municipalities that prohibit specific breeds of dogs must make an exception for a service animal of a prohibited breed, unless the dog poses a direct threat to the health or safety of others. Under the direct threat provisions of the ADA, local jurisdictions need to determine on a case-by-case basis whether a particular service animal can be excluded based on that particular animal's actual behavior or history, but they may not exclude a service animal because of fears or generalizations about how an animal or breed might behave. It is important to note that breed restrictions differ significantly from jurisdiction to jurisdiction. In fact, some jurisdictions have no breed restrictions. Exclusions of service animals. When can service animals be excluded? The ADA does not require covered entities to modify policies, practices, or procedures if it would fundamentally alter the nature of the goods, services, programs, or activities provided to the public, nor does it overrule legitimate safety requirements. If admitting service animals would fundamentally alter the nature of a service or program, service animals may be prohibited. In addition, if a particular service animal is out of control and the handler does not take effective action to control it, or if it is not housebroken, that animal may be excluded. When might a service dog's presence fundamentally alter the nature of a service or program provided to the public? In most settings, the presence of a service animal will not result in a fundamental alteration. However, there are some exceptions. For example, at a boarding school, service animals could be restricted from a specific area of a dormitory reserved specifically for students with allergies to dog dander. At a zoo, service animals can be restricted from areas where the animals on display are the natural prey or natural predators of dogs, where the presence of a dog would be disruptive, causing the displayed animals to behave aggressively or become agitated. They cannot be restricted from other areas of the zoo. This is a real important section here. What does under control mean? Do service animals have to be on a leash? Do they have to be quiet and not bark? The ADA requires that service animals be under the control of the handler at all times. In most instances, the handler will be the individual with a disability or a third party who accompanies the individual with a disability. In the school K through 12 context and in similar settings, the school or similar entity may need to provide some assistance to enable a particular student to handle his or her service animal. The service animal must be harnessed, leashed, or tethered. And in that section, we're solely talking about restraint on the dog of some form. It could be a harness, it could be a leash. They're talking about the dog must be restrained in some manner while in public places unless these devices interfere with the service animal's work or the person's disability prevents use of these devices. I once knew a paraplegic that could not, arms, hands didn't work. Well, they didn't work effectively. They had a little bit, the fingers had a tiny bit of function. This person controlled their service dog through an e-collar, and they had certain signals, sound or buzz, vibration signals to signal the dog what they wanted the dog to do. So that would be an instance of a person that could not use a physical restraint form. In that case, the person must use voice, signal, or other effective means to maintain control of the animal. For example, a person who uses a wheelchair may use a long retractable leash. Never, ever, ever, ever use a retractable leash. They are evil. Retractable leash to allow her service animal to pick up or retrieve items and trip everybody that is not watching where they're walking. I would never do that. It's a bad idea. You could hurt somebody that way. You could hurt your dog. She may not allow the dog to wander away from her and must maintain control of the dog, even if it is retrieving an item at a distance from her. So they're talking about you must have control of your dog at all times. If you're going to drop the leash or remove the leash for the dog to do what you've told the dog to do, you must have voice control or other ways to absolutely control the dog. Or a returning veteran who has PTSD and has great difficulty entering unfamiliar spaces may have a dog that is trained to enter a space, check to see that no threats are there, and come back and signal that it is safe to enter. The dog must be off leash to do its job. but may be leashed at other times. Under control also means that a service animal should not be allowed to bark repeatedly in a lecture hall, theater, library, or other quiet place. However, if a dog barks just once or barks because someone has provoked it, this would not mean that the dog is out of control. I would beg to differ. You can teach your dog to not bark even if being provoked. This is my opinion, not law. My opinion is the dog should not bark unless it is summoning help for a medical crisis to its handler. That, the dog shouldn't be carrying on and barking. That would be the only good reason for a dog to be barking, is if it's summoning help, emergency help to its handler. What can my staff do when a service animal is being disruptive? If a service animal is out of control and the handler does not take effective action to control it, staff may request that the animal be removed from the premises. Are hotel guests allowed to leave their service animals in their hotel room when they leave the hotel? No. The dog must be under the handler's control at all times. What happens if a person thinks a covered entity's staff has discriminated against him or her? Individuals who believe that they have been illegally denied access or service because they use service animals may file a complaint with the U.S. Department of Justice. Individuals also have the right to file a private lawsuit in federal court charging the entity with discrimination under the ADA. And I would like to add that many places have advocacy groups, disability advocacy groups, some for the ADA, some for housing, some for all of it. If you run into a problem, I would highly suggest the first place you go is to find a local advocacy group in your state or even in your town and talk to them first. That's what I would suggest. Miscellaneous. Are stores required to allow service animals to be placed in a shopping cart? Generally, this generally means, occasionally maybe, but not always. Generally, the dog must stay on the floor, or the person must carry the dog, or provide their own device to cart the dog around. For example, if a person with diabetes has a glucose alert dog, he may carry the dog in a chest pack so it can be close to his face to allow the dog to smell his breath to alert him of a change in glucose levels. If a dog is in a cart, it still could be a reasonable accommodation for a dog to be in a cart, but it's not an automatic. You would have to go to the management and seek permission if they don't allow dogs in carts, and they can choose to. This does not prohibit them from choosing to allow it. But if they don't allow the dogs in the carts, one would have to go to the manager and seek permission to put their service dog in the cart. And they would have to explain what about their disability. Maybe they cannot carry their dog. Maybe their body is not strong enough to put the dog in a pack and carry it that way. There are very isolated situations where it might be needed to put the dog in the cart, but they would have to seek and get special permission for that. Just like my daughter used to work her service dog off leash at school. She had to seek specific permission to do that. That wasn't her right, and she knew it. She actually had to go to the administration and formally ask for permission to work her dog off leash because it was safer in the extremely crowded school environment. It was safer for her dog to be off leash. And so she was granted that. So you can seek permission for things that are generally not allowed. You can seek permission in a private place or business or a school or whatever. They can choose to allow it and give you permission. Are restaurants, bars, and other places that serve food or drink required to allow service animals to be seated on chairs or allow the animal to be fed at the table? No. Seating, food, and drink are provided for customer use only. The ADA gives a person with a disability the right to be accompanied by his or her service animal, but covered entities are not required to allow an animal to sit or be fed at the table or off the utensils intended for humans. The dog belongs under the table, laying down, behaving itself. That's where dogs belong. If there's no room under the table, and that happens a lot, if there is no room under the table, the dog belongs in the closest location where the dog's not going to be in walkways. The dog needs to be out of the way. So if the table is of a small type where the dog won't comfortably fit underneath it, I'll put my dog, to the side of me that is away from the walking areas. The dog needs to be out of the way, and it needs to be laying down, and it needs to be quiet, and it needs to not beg. That's advice. I don't think they have that here in the law, but it's good advice. They need not to beg. Are gyms, fitness centers, hotels, or municipalities that have swimming pools required to allow a service animal in the pool with its handler? No. The ADA does not override public health rules that prohibit dogs in swimming pools. However, service animals must be allowed on the pool deck and in other areas where the public is allowed to go. Are churches, temples, synagogues, mosques, and other places of worship required to allow individuals to bring their service animals into the facility? No, they're not. Religious institutions and organizations and the premises they own, if they provide something to members only, it applies to that too. Religious institutions and organizations are specifically exempted from the ADA. However, there may be state laws that apply to religious organizations. And on that one, I'd say, if they're not going to allow a legitimate service dog, do you really want to worship there? That would be my thought. Jesus said to love others and to freely allow others in. So if they're not going to allow you and the dog that God made in with you, do you really need to go there? Are they really going to be teaching you good stuff? Just saying. Do apartments, mobile home parks, and other residential properties have to comply with the ADA? The ADA applies to housing programs administered by state and local governments, such as public housing authorities, and by places of public accommodation, such as public and private universities. In addition, the Fair Housing Act applies to virtually all types of housing, both public and privately owned, including housing covered by the ADA. Under the Fair Housing Act, which is a completely separate law with different standards and definitions, under the Fair Housing Act, housing providers are obligated to permit, as a reasonable accommodation, the use of animals that work, provide assistance, or perform tasks that benefit persons with a disability, or provide emotional support to alleviate a symptom or effect of a disability. For information about these Fair Housing Act requirements, see HUD's Notice on Service Animals and Assistance Animals for People with Disabilities in Housing and HUD-funded programs. And we will get to that one as well. Do federal agencies such as the U.S. Department of Veterans Affairs have to comply with the ADA? No. Section 504 of the Rehabilitation Act of 1973 is the federal law that protects the rights of people with disabilities to participate in federal programs and services. For information or to file a complaint, contact the agency's Equal Opportunity Office. Do commercial airlines have to comply with the ADA? No. The Air Carrier Access Act, another law with completely different separate requirements and definitions. Once again, completely separate law. The Air Carrier Access Act is the federal law that protects the rights of people with disabilities in air travel. For information or to file a complaint, contact the U.S. Department of Transportation Aviation Consumer Protection Division, and it gives the phone number. Let me scroll that up so you guys see the phone number. Now, on the note of air flights and airlines and airports, the ADA would apply to the airport, where you walk in and where you do your thing, you get your ticket. The ADA applies there. The minute you step onto the plane, we're under the ACAA at that point. You know, so just be aware of that. Now, the ADA does not allow for emotional support animals, but because the ACAA does, they will allow the emotional support animals into the airport. They are allowed into the airport to board a flight because the ACAA allows it. So, but generally, the ADA covers the physical airport itself. All right, well, we're done with this one. That was long. I want to hit the actual text. You know, it should be very quick. This is the long version. The text in the law is kind of the short version. But I'll real quick cover the short, you know, actual text of the law, and then we're done with this overview of, you know, the laws surrounding the service dogs and the ADA. Okay, I've linked over. Remember at the initial, at the beginning, I said I was going to link over to that other document. Well, I've gone over to the other document. I'm going to try to make it quick. This is not the text of the law. I thought it was, but it's not, but it's still important. So there's some things in here. It's the 2011 guidance. There are some things in here that weren't detailed in the other one. So I just want to hit those so everybody is aware of them, so they can't go, well, I didn't know. All right. Right here. Beginning on March 15th, 2011, only dogs are recognized as service animals under Title II and III of the ADA. That was not stated in the other one, but that is a thing. I'll reread this document's definition on service animal. Service animals are defined as dogs that are individually trained to do work or perform tasks for people with disabilities. Disability, again, being a legal term. Examples of such work or tasks include guiding people who are blind, alerting people who are deaf, pulling a wheelchair, alerting and protecting a person who is having a seizure, reminding a person with mental illness to take prescribed medications, calming a person with PTSD during an anxiety attack through trained behaviors, or performing other duties. Service animals are working animals, not pets. This is a legal thing right here, so be very aware of this. Service animals are working animals, not pets. They're actually considered medical devices, like medication or a wheelchair. So keep that in mind in all your dealings. Service animals are working animals. They are medical devices, not pets. The work or task a dog has been trained to provide must be directly related to the person's disability. Dogs whose sole function is to provide comfort or emotional support do not qualify as service animals under the ADA. So let's look at that again. The work or task a dog has been trained to provide must be directly related to the person's disability. That means I have a friend who's blind. I actually do. I helped her train her guide dog. I have a friend who's blind. Her dog is considered a service dog because it assists her with her blindness. It is a guide dog. She hands that dog to me. I am illegal to take that dog into public as my service animal. I can, if she were in the hospital, I could be a friend transporting the dog to and from her, but taking the dog as my own service animal into public, I would be illegal. Why would I be illegal? Because it's an actual service animal. I would be illegal because I can see the tasks the dog does, guiding a blind person, doesn't address my problems. And the work the dog does has to address your specific problems. So you need to keep that in mind. And that goes for so-called service dogs up to be given away or for sale in a paper, on the internet, whatever. Even if the dog is properly trained, which is very doubtful, you need to be concerned, does what that dog is trained to do, does it assist your problem? Because if it doesn't, it's not a legal service dog for you. Very important to understand. This definition does not affect or limit the broader definition of assistance animal under the Fair Housing Act, or the broader definition of service animal under the Air Carrier Access Act. So, for purposes of fair housing, ACEs and service dogs are lumped together and called assistance animals. In the Air Carrier Access Act, service dogs and ACEs are lumped together and all called service animals. I don't know why. We need to all get on the same page here. Some state and local laws also define service animal more broadly than the ADA does. Information about such laws can be obtained from the State Attorney General's office. Under the ADA, state and local governments, businesses, and all nonprofit organizations that serve the public generally must allow service animals to accompany people with disabilities in all areas of the facility where the public is normally allowed to go. For example, in a hospital, it would be inappropriate to exclude a service animal from areas such as patient rooms, clinics, cafeterias, or examination rooms. However, it may be appropriate to exclude a service animal from operating rooms or burn units where the animal's presence may compromise a sterile environment. Now, how you're going to know it's a sterile environment, it's those places where you have to gown up. Mask and hat, and where you have to gown up. Those are sterile places because they even make you get sterile. So those places the dog could be excluded. And then we're talking about being under control. Under the ADA, service animals must be harnessed, leashed, or tethered. We're talking about physical restraint, not IDing the dog as a service dog. Unless these devices interfere with the service animal's work or the individual's disability prevents using these devices. And it just goes on to say that if you can't use the restraint, voice, signal, that kind of thing. Then we talk about what the questions the public gatekeepers might ask. Allergies and fear of dogs are not valid reasons for denying access or refusing service to people using service animals. Let's listen to that again. Allergies and fear of dogs are not valid reasons for denying access or refusing service to people using service animals, because we've all encountered it a million times. When a person who is allergic to dog dander and a person who uses a service animal must spend time in the same room or facility, for example, in a school classroom or at a homeless shelter, they both should be accommodated by assigning them, if possible, to different locations within the room or different rooms of the facility. So if an allergy is bad enough, they have to serve both people. They have to separate them. They have to accommodate both of them, figure out, what will work. Then they go into when you can remove a service animal. Establishments that sell or prepare food must allow service animals in public areas, even if state or local health codes prohibit animals on the premises. Premises, yes. People with disabilities who use service animals cannot be isolated from other patrons, treated less favorably than other patrons, or charged fees that are not charged to other patrons without animals. And that's kind of what Title II says. That's kind of the wording in Title II, state and local government, when we're talking about like county licensing for dogs. That's what it says. They can't be charged fees that are not charged to other people without animals. But we can visit that another time. In addition, if a business requires a deposit or fee to be paid by patrons with pets, it must waive the charge for service animals. So all through the ADA, they talk about you can't charge for these animals, but a license is a charge to be in the county with the animal. So if I took that to court, and I don't have the money to do that, if I'm provided an opportunity where I don't have to pay for it, I will. Charging a fee is not appropriate. Staff are not required to provide care or food for an animal. And then here's the blurb on miniature horses, which are also allowed to be service dogs. Let's read this real quick.
Pony.
Huh?
Service pony.
Service pony, my son says. Okay. In addition to the provisions about service dogs, the department's revised ADA regulations have a new separate provision about miniature horses that have been individually trained to do work or perform tasks for people with disabilities. Miniature horses generally range in height from 24 inches, which is how tall my service dog is, to 34 inches, measured to the shoulders, and generally weigh between 70 and 100 pounds. My service dog weighs 105 pounds. Entities covered by the ADA must modify their policies to permit miniature horses where reasonable. The regulations set out 4 assessment factors to assist entities in determining whether miniature horses can be accommodated in their facility. The assessment factors are: 1, whether the miniature horse is housebroken, and they can be housebroken. 2, whether the miniature horse is under the owner's control. And 3, whether the facility can accommodate the miniature horse's type, size, and weight. And 4, whether the miniature horse's presence will not compromise legitimate safety requirements necessary for safe operation of the facility. So that is the guidance on miniature horses. Okay, here we are finally at the text of Title III of the ADA. Finally. All right, let me go through it. It's not horribly long. All the guidance is longer. So it's 28 CFR 35.136 service animals. A, general. Generally, a public entity shall modify its policies, practices, or procedures to permit the use of a service animal by an individual with a disability. B, exceptions. A public entity may ask an individual with a disability to remove a service animal, or they'll call animal control out to do it, from the premises if the animal is out of control and the animal's handler does not take effective action to control it, or the animal is not housebroken. If an animal is properly excluded, if a public entity properly excludes a service animal under 35.136B, it shall give the individual with a disability the opportunity to participate in the service program or activity without having the service animal on the premises. Animal under handler's control. A service animal shall be under the control of its handler. A service animal shall have a harness, leash, or other tether, we're talking about restraint devices, unless either the handler is unable because of a disability to use a harness, leash, or other tether, or the use of a harness, leash, or other tether would interfere with the service animal's safe, effective performance of work or tasks. In which case, the service animal must be otherwise under the handler's control. For example, voice control signals or other effective means. Care or supervision, that's E. A public entity is not responsible for the care or supervision of a service animal. Inquiries, which is F. A public entity shall not ask about the nature or extent of a person's disability, but may make 2 inquiries to determine whether an animal qualifies as a service animal. A public entity may ask if the animal is required because of a disability and what work or task the animal has been trained to perform. Notice in the law, it doesn't give a script for what is said. They just tell you a question about this and a question about that. Some people they want to insist it has to be in the form that is in the guidance. That's not what's in the law. A public entity shall not require documentation, such as proof that the animal has been certified, trained, or licensed as a service animal. Generally, a public entity may not make these inquiries about a service animal when it is readily apparent that an animal is trained to do work or perform tasks for an individual with a disability. For example, the dog is observed guiding an individual who is blind or has low vision, pulling a person's wheelchair, or providing assistance with stability or balance to an individual with an observable mobility disability. G. Access to areas of a public entity. Individuals with disabilities shall be permitted to be accompanied by their service animals in all areas of a public entity's facilities where members of the public, participants in services, programs, or activities, or invitees, as relevant, are allowed to go. I'm going to scroll this up. Surcharges. A public entity shall not ask or require an individual with a disability to pay a surcharge, even if people accompanied by pets are required to pay fees or to comply with other requirements generally not applicable to people without pets. If a public entity normally charges individuals for the damage they cause, an individual with a disability may be charged for damage caused by his or her service animal. Miniature horses. Reasonable modifications. A public entity shall make reasonable modifications in policies, practices, or procedures to permit the use of a miniature horse by an individual with a disability if the miniature horse has been individually trained to do work or perform tasks for the benefit of the individual with a disability. Assessment factors. In determining whether reasonable modifications in policies, practices, or procedures can be made to allow a miniature horse into a specific facility, a public entity shall consider 1. The type, size, and weight of the miniature horse, and whether the facility can accommodate these features. Whether the handler has sufficient control of the miniature horse. And shut up, Facebook. Whether the miniature horse is housebroken, and whether the miniature horse's presence in a specific facility compromises legitimate safety requirements that are necessary for safe operation. 3. Other requirements. Paragraphs 35.136C through H of this section, which apply to service animals, shall also apply to miniature horses. Done. Done. We're done. So that's it. That is all the guidance and the actual text of the law on service dogs. And are you wore out? I'm worn out. So there are specific issues, like the conflict between Title II and the guidance. We'll get to those later, because, this is drug on for a really long time. So I'm ready to be done. Are you ready to be done? I'm ready to be done. So anyway, I guess I'll see you at the next video. Bye.